It is like that 7:05, so we'll open up the March 25th, 2021 meeting of the Middleton Zoning Board of Appeals. There are 4 new public hearings for tonight. However, first we're going to start with the minutes from the February 25th meeting. Does anybody have any comments on the minutes as submitted?
Well, look good. I'll move we accept the minutes as read.
Is there a second?
Second.
And vote?
Craig?
Yes.
Rich?
Yep.
Ann?
Yes.
And I'll vote yes.
Thank you. All right, so we have the 4 new public hearings tonight. I guess we'll just take them in order. We'll start with 319 North Main Street. That is Midtown Place LLC. It is an appeal pursuant to the zoning bylaw section 9.1.6. Are the applicants here in the waiting room? Or if there's anyone in the waiting room that would like to be heard, can you please just raise your hand?
We have everyone here that should be here.
Excellent. So, Madam Clerk, would you please read the legal notice?
Sure. Katrina puts it up. I will. Okay. The Zoning Board of Appeals will hold a public hearing 7 p.m. March 25th at a virtual meeting on the application of Midtown Place LLC pursuant to section 9.1.6 of the zoning bylaw and GLC 40840A for an appeal of the building commissioner's decision dated January 5th, 2021, denying the building application and C20 00071 and any other relief the Zoning Board of Appeals deems appropriate. The proposal is located on property located at 319 North Main Street, found on Assessor's Map 9, Parcel 59. And the appeal is on file at the town clerk. I'm assuming the applicants have been notified, the abutters rather.
Yes, they are. They have been.
Thank you. And the comments, are there comments?
I think what we'll do is I'll let the applicants and the representatives make their presentation, and then we'll come back with any correspondence we've received from the town, and then open it up to town planner, the building commissioner, and anyone from the town to respond. So, okay, is there anyone here to speak in favor of the applicant?
Good evening, Chairman Hartmell. I'm Peter Nectum. I'm the attorney for the applicant.
Hi, welcome.
Thank you very much. Good evening, members of the board. So I represent Midtown Place LLC in this matter. Again, my name is Peter Nectum. I'm an attorney at McLean, Holloway, Doherty, and Sheehan in Peabody. I understand that you're all quite familiar with the 319 North Main Street property, as it's been the subject of numerous proceedings, both in this venue and others. As you know, the property is located in the M1 Light Industrial District. At issue is the property's prior non-conforming motel use. Tonight, we're dealing with questions as to whether there's been an abandonment or a 2-year period of non-use so as to terminate the prior non-conforming motel use. Your zoning bylaw is consistent with Chapter 48, Section 6. It provides that a non-conforming use which has been abandoned or not used for a period of 2 years loses that protected status. I've submitted a memorandum and a number of exhibits in support of our position that my client and its predecessor in title are guilty of neither abandonment nor a 2-year period of non-use. So as to abandonment, it requires both intent to abandon and a voluntary conduct which carries the implication of abandonment. The facts, as I've laid out in my memorandum, demonstrate that there was neither intent to abandon nor any voluntary conduct by my client or its predecessor in title that would imply abandonment of the prior non-conforming motel use here. Those facts demonstrate just the opposite. Both my client and its predecessor took affirmative actions in furtherance of preserving the motel use. Just to briefly summarize those actions. My client's predecessor timely appealed denials of building permit applications following a April 5th, 2014 fire at the property. And over the next 4 years, he spent tens of thousands of dollars prosecuting those appeals and defending against the town's counterclaims in an attempt to get the motel back up and running. My client acquired the property on March 1st, 2019, and continued the efforts of its predecessor. By applying for a building permit on April 25th, 2019, so as to begin addressing the numerous code violations, obtaining Title V inspections of the property's septic systems in December of 2019, so as to make sure those systems were sufficient for continued motel use. And after the inspection revealed that portions of the property's septic systems were located on an adjacent 8 Piedmont Street parcel, acquiring that parcel in December of 2020. We're comfortable that all of that action is consistent with the intent to preserve rather than abandon the prior non-conforming motel use. But there's also been no 2-year period of non-use. We're not disputing that the building has not been occupied since the April 5th, 2014 fire. However, the case law instructs that mere vacancy for a period of 2 years or more does not, as a matter of law, equal non-use so as to cause loss of that non-conforming status. I'm specifically citing the case of Corbett versus Chin, and it's a 2015 land court case, so it's relatively recent. I submitted a copy of that decision through your clerk via email. I also uploaded it to your online portal earlier today. But the case dealt with a prior non-conforming 2-family dwelling where one of the units sat vacant for a period in excess of 2 years. And the fight in that case was over whether the property had lost its prior non-conforming status. Judge Speicher in the land court, he said in that decision that in order to conclude that the unit had not been used for a period of 2 years, the evidence would have to show not only that there was no tenant occupying the unit, but that there was no effort to rent or otherwise occupy the unit or maintain it as a dwelling unit. So in this case, there's no evidence of any lack of effort by my client or his predecessor over any 2-year period to maintain the property or preserve the non-conforming motel use. To the contrary, the evidence shows that almost immediately following the April 5th, 2014 fire, my client's predecessor applied for a building permit to repair that damage. When that application was denied, it led to litigation that lasted from July 14, 2014 until judgment entered on May 25, 2018. And based on the Brown versus the City of Revere case that I cited in my papers, which says the 2-year period of non-use is stayed during the pendency of such litigation. In this case, any 2-year period of non-use would begin on May 25, 2018. That's the date when judgment entered in the lawsuit in the town's favor that my client's predecessor had filed. And that judgment you'll find that at Exhibit N to my submission. So based on the Corbett case, which I just discussed, we say there's been no 2-year period of non-use since May 25, 2018, the date of that judgment. And it's important to note that from May 25, 2018 to the present, the following has occurred. My client acquired the property on March 1st, 2019, and you'll see that deed at Exhibit G to my submission. On April 25, 2019, was a month or so after my client purchased the property, it applied for a building permit to remove and dispose of all walls, ceilings, kitchens, bathrooms, and fixtures from the 3rd floor and the basement. And that application that was filed back on May 25, 2019 you'll find that at Exhibit K to my submission. So the next day, April 26, 2019, my client had the Inspectional Services Department and the Fire Department out to the property to inspect the premises and discuss my client's plans for remediation of the numerous violations. Subsequently, for financial reasons, my client had to put its motel renovation project on hold, and it had to withdraw its building permit application. And you'll find email correspondence from my client to Mr. Fitzpatrick to that effect in Exhibit K to my submission. December 5, 2019, my client was ready again to proceed and commissioned Title V inspections of the septic systems on the property to ensure they were sufficient for continued use as a motel. You'll find those reports at Exhibit H to my submission. At that time, when it was discovered that portions of the septic systems were actually located on the 8 Piedmont Street parcel, which is adjacent, my client recognized that it was going to have to acquire that parcel in order to proceed. And for the next year, my client sought to acquire that parcel. Finally was able to do it in December of 2020. And you'll see that deed at Exhibit M to my submission. That year-long lag between when my client recognized that it had to acquire the 8 Piedmont Street property and when it actually did, it's because the prior owner had to clear up a real estate attachment on the property before it could be conveyed. And as soon as that issue was resolved, my client purchased the 8 Piedmont Street property and then pretty much immediately filed the building permit application that's was denied, and it's the subject of this appeal. So at Exhibit L to my submission, actually the first page to that exhibit, you'll find some email correspondence from my client to Mr. Fitzpatrick, where she's explaining that situation. So our position is all of that action is consistent with an effort to maintain or preserve the prior non-conforming motel use. This isn't a case where my client or its predecessor simply let the property sit vacant for a period of 2 years or more without making any effort to occupy or maintain it as a motel use. So we believe that the case law is going to support our position that there's been no 2-year period of non-use, as well as no abandonment. Now, just briefly, as to the building inspector's second reason for denying the building permit, that the work proposed in my client's application does not address all the zoning violations that are identified in the building commissioner's October 13, 2016 order. And you'll find that in my submission as well at Exhibit J. Respectfully, I'll submit to you that that reason is not supported by the language of Judge Howe's May 25, 2018 judgment or the zoning bylaw. Judge Howe's May 25, 18 judgment, which is Exhibit I to my submission, it doesn't affirm the building commissioner's October 13, 2016 order. It doesn't say that anywhere in Judge Howe's judgment. Neither the judgment nor the zoning bylaw require that all the zoning violations be addressed via one building permit application. And to the extent that the building commissioner is saying that he can't issue the building permit that we've requested because we haven't secured zoning relief to continue the prior non-conforming motel use, we say that that use hasn't been terminated for the reasons I just described, and that we don't need that zoning relief. So for those reasons, our position is that the January 5 decision of the building commissioner to deny our building permit was error, and we're asking you, the board, to overturn that decision and order the issuance of that permit. So, thank you for letting me address you, and happy to answer anything you have for me.
Thank you, Counselor. Is there anyone else here to speak in favor of the applicant? Seeing none, I will open it up for correspondence. Madam Clerk, do we have any?
All right, this is from Middleton Electric Light, dated February 26, 2021, 319 North Main Street. Meld has no conflict with this project.
Sorry, that's all we have.
That's all? No.
Mm-hmm.
Okey-dokey.
In that case, I guess, does town council want to begin, or I guess Rich or Scott, can you do you want to go first?
It doesn't matter, either Jay or I can go first.
So I think that
This is an interesting matter. It obviously has a long history, most of which you are at least somewhat familiar. And Scott certainly is really familiar too. I think that Attorney Nectum did a nice job in terms of kind of framing the law generally, but it's a little bit more broad than that. And it is a very fact-specific inquiry. You can't prove, and it is their burden of proof in all circumstances. And it is a fact-by-fact, case-by-case analysis by the board in all circumstances, and you're entitled to deference in any of that. There's no magic. You can't just say, I applied for a permit here or there, and I automatically escape the question of non-use or the question of abandonment. There has to be a bona fide effort in the opinion of the board, and the cases, including the cases that are generally relied upon by the applicant, state in those facts, it's not enough just to have something in a file. There has to be a genuine effort to pursue and diligently the permits that you need. Here, it's clear, even though there might be some disagreement as to whether or not there's a full stay here, that there is more than 2 years from the date of the judgment to the date of the building permit application. During that period, I think we've heard from them. There wasn't much happening. They applied for a permit. They withdrew that permit. They were looking at some demolition issues. They walked away from that. They had some Board of Health stuff, and they eventually looked to buy those properties. Are those all facts worthy of consideration by the board, which ultimately has to make a decision on this? They are. Do they automatically support the applicant? They do not. The mere fact that there's blips along a timeline doesn't necessarily mean that there hasn't been non-use or there hasn't been abandonment. There has to be potentially something more than that, according to the cases. Now, a board, whichever way you're going to go, based upon the facts before you, you're likely to be afforded deference. If you feel that the 2 or 3 points along the timeline where the applicant has checked in on potential use of this property are enough, you're going to be afforded deference in any challenge on that by a neighbor or anyone else. It would be reasonable to conclude that way. However, based on the case law, if you decided that there was a couple points where they checked in, they looked at a permit, they withdrew it, they were looking at a septic system on another lot, but they didn't actually start using the property within that 2-year period, and you determined, as the building commissioner has determined, and he's more familiar with the property than any of us, that there hasn't been sufficient use within the last 2 years, and that is not enough to overcome their burden or to satisfy their burden that there's been some robust effort, then that would be afforded deference too, in my opinion, based on the cases, including particularly the Chirlucci case out of the town of Wareham, which lays it out quite clearly that it's fact by fact, and that mere couple points in the timeline where an applicant is going to do something is not particularly enough. So ultimately, the board has to kind of put this in a balancing test a little bit and see if, in deference to Scott and his long history with this project, if the mere couple of times that they've done something but never actually used the property since 2018 are enough for them to save the pre-existing non-conforming use. While the issue isn't particularly relevant to this, it's also important to note that if you deny this appeal, which means you would be upholding the denial of a building permit, the applicant isn't without a remedy. This is not a situation where they would have to get a use variance. They could have one of 2 different special permits to revive a motel use here, at which time they could satisfy the permit granting authority that the motel use is an appropriate use for this site. And there is a long-standing tenet of law regarding pre-existing non-conformings that they over time are to expire and allow for zoning bylaws to operate to bless the new uses that may be permitted. So there is an opportunity here for them. That's not strictly relevant to the issue of abandonment or not abandonment, but I think it's important to have that by way of context, that the use is not necessarily dead on arrival, provided that the applicant go through a process whereby the motel use that they are intending to do would have the kind of review that any new motel use would have. But for tonight, I think what you have to decide is whether or not the limited 2 or 3 things cited by Mr. Nectum are enough to overcome and cause you to reverse the decision that Scott made after consideration of a lot of facts. And I can attest to you, because I have some of these documents too, there are boxes and boxes of documents supporting what Scott did here. So again, I can't give you a definitive answer here. I can only lay it out that that there's support for both sides of this, and that there's no bright line test that says that just a mere couple of actions over a course of 2 years are enough to satisfy either the non-use question or the abandonment question. So I'll take questions if you have them too.
Thanks, Jay. Before we take questions, Scott, did you want to make a statement?
Yeah, I can. And I actually just wanted to touch first on the second reason that Attorney Necton brought up, which was one of the reasons the permit was denied was because it didn't address all the zoning violations in the property. Some of you sat on the board who heard the first appeals on this to my predecessor. The original building permit application after the fire, the reason it was denied was because of the zoning violations at the property, and the building permit did not address those. That's the case that was litigated in Essex Superior Court. It was my first month here. The town was successful in that one, and the court upheld the board's decision to uphold the building commissioner's denial of the permit based on the zoning violations on the property. So the second reason stating that he doesn't have to remove all the violations in order to get a building permit, that was really the whole first court case. This was the one that was heard up in Newburyport on the first appeal. So, I mean, I think that, my opinion, I'm not an attorney, but I think that one's pretty clear. I think our ordinance is our bylaw is pretty clear on that one. And then as far as the timeline laid out by Attorney Nectum, I mean, his dates seem to be on. The fire was April 5th, the first building permit, November 2014, the appeals. In fact, I didn't take any time when I figured my 2 years during any of the litigation. I strictly used the judgment date of the second court case, which was the result of the appeal of the orders I wrote after being allowed in the property as part of the judgment of the first court case. So everything I did was based off the May 25th, 2018 date. And as Attorney Talaman and Attorney Necton both laid out, although apparently there was some very minor uses, maybe some emails checking in from time to time, the only attempt at actually doing anything was applying for a permit and withdrawing it. And I will say the date, we went out to the site the very next day after the permit application came in. Attorney Necton referenced that was April 26th. At the end of that walkthrough, that was done with myself, my plumbing inspector, wiring inspector, Chief Martinook from the fire department, and a couple of his fire prevention guys. We were told by the representative of Midtown Place at the site not to act on the building permit at that point because it needed to be she basically needed to think about it. And roughly a month later is when I sent an email checking in that we had the incomplete permit or unissued permit, in which she instructed me to withdraw it. And she was going to concentrate, I believe, on the 11 at the time, or the 4 other properties that she stated. So, that's basically it. So, the only interaction we had was other than a few checking in emails, was the permit application, site visit the next day, the verbal put it on hold, and the official withdrawal that they were going to concentrate on the 4 other properties.
Thanks, Scott.
Thank you.
Anyone else from the town wish to speak? Seeing none, I will open it up. Is there anyone from the public here that wishes to speak on this? I don't see any hands raised. I will open it up to board discussion. Questions? Rich?
This maybe is a little bit of background here. I hear a non-conforming use, but it's a motel. And then I hear in the description that there were kitchens and so forth. So I guess I need a little bit of clarification. I consider a motel as sort of transient. You come, you stay a few nights, maybe you stay a week, and you move on. And then I'm hearing about kitchens and things like that. So was this a motel use, or was it long-term rentals? Or does someone have an explanation for that? Because I'm a little unclear, because I'm hearing kitchens and all this other stuff.
When Mr. Benevento, when I did my inspection in 2016, the motel was actually shut down. It had been vacant with no power since the fire in 2014. So I can't speak to how they were being occupied, as far as if it was nightly rentals, weekly rentals, or something non-transient, which, would throw us into a whole nother category with the building code, because that would have been a change of use. I cited what I saw when I went through these units. Some of them look like apartments, and if you read my 2016 order, it's pretty detailed. Some of them were full-blown apartments, some were hotel rooms, some were sort of efficiency units. Chief Montnook, who's, I believe, on the call, is also very familiar with the property, and he might be able to give you more of a description of how it was occupied, because, Chief was around when it was operating. But what I will say is this permit was to remove the illegal work. Some of it, not all of it. So I don't think the case is being made to turn it into apartments or keep that. I think it's, there's a matter of the permit was for the attic and for the basement, but there's also some illegal rooms and units on the second floor as well that I didn't feel were being addressed.
Okay, so it sounds like we would be going to a non-conforming motel use versus a non-conforming apartment residential type use.
Well, it's never legally been an apartment or residential use. Whether people were staying beyond the 30 days identified in the building code as kind of the trigger for transient, that I don't know.
Okay.
And if they did, that would trigger a whole change of use under the building code.
Okay, thank you. Thank you, Mr. Chairman.
Is there any other questions from the board?
Scott, can you explain the basis?
And hold on, Anne LeBlanc,
Sorry.
just, I think you're
Sorry.
muted. Just don't forget.
So I was on the board way back when, and I remember this. So I'm not really following, like, the issue here is about issuing a building permit, but it's not for all the work that needed to be done to take away those illegal apartments and the fire department issues. I mean, there were like smoke detector issues. And so I'm not following. Are we talking about giving a building permit for some of the work, but then leaving other portions of that motel as a residential property? I'm a little unclear on what is being asked for here. Like, Scott can maybe clarify that for me.
Okay, the application was kind of vague, and I did ask for a more detailed description of work, but both court cases identify the number as 54 motel units or rooms, whatever we're going to call them, is what the court has decided was legal in that building. That was going through the course of, I don't know, 3 or 4 additions, some site plan approvals, and there was and that was decided by the court. If you look at the 2016 order, and I'd have to go through and count them, but there was an excess of 10 additional units. Some of those were on the 3rd floor. Some of those were on the 2nd. One area, there was a back unit which looked like it had been turned into an apartment around the pool area on the 2nd floor overlooking into the pool. That was one of the ones that was cited in the order. And then there was the cave rooms in the basement. The order called for the attic to be gutted 100%, the basement to be gutted, and the 1st and 2nd floors to be returned to the 54 units that were properly permitted. In the application sounded like it was only talking about the attic and the basement.
So you have, I'm sorry.
So that still would leave them with units in excess of 54.
Okay. So I'm sorry. So you have a concern, as do I, that there are still these strange units existing in that building on the 1st or 2nd floor.
Yes, my feeling is I'm not going to issue a building permit that doesn't comply with the orders that were issued initially by me. And I do disagree with Attorney Nectum that the court did uphold the order that it's 54 units and did not strike my order that I wrote in 2016. I wrote one for every property down there. I know we spent, I forget how many days going through detailing room by room what was in these buildings.
I remember that. I remember that, and it was scary. And I agree that caution needs to be taken here, that this is not allowed to happen again. So I'm done.
Yeah. And Cody, did you have something? I'm sorry, I didn't mean to cut you off before.
No, that's okay. I kind of had the same question as Ann. I'm not sure exactly what we're voting on. What are we being asked to vote on specifically?
Jay,
Yes, we're voting to uphold Scott's order of whatever it is.
That's correct. That's the sole question before you. Scott denied for essentially 2 reasons. One reason was abandonment or non-use for 2 years under that bylaw. Okay. And then the second reason was that there has not been full compliance. Okay. The primary question I would say for you, although I'm not diminishing the second question, is the question of abandonment or not use, and that's the one that I spoke about mostly before.
And Scott, are you feeling fairly confident that neither of those things have happened?
I wouldn't have abandonment. I wouldn't have denied the permit if I wasn't confident that.
Right. Okay. Good. Okay. And what does Chief Tom have to say about it?
Well, I agree with Scott. In my opinion, this is my opinion because I was there. Benvenue and I shut it down after the initial fire, and they've had 7 years to do what they need to do to get that up to code. And it's my opinion that instead of fighting the town, they fought the town instead of doing what they needed to do. So I'm not going to bore you with my personal opinions, but I agree with Scott. This thing has been going on for 7 or 8 years now, and it's obviously it's up to you guys, but I agree totally with Scott.
Okay, thank you, Tom.
Rich?
Yeah, just sort of a follow-on. So it sounds like that the work was going to be in the basement and in the attic, 3rd floor or whatever that is. Is that right? That's what was on the building permit. And if that's the case, for a building that's been not used, regardless of what the legal terms are, abandonment or whatever it is, this wouldn't appear to pass the smell test for me that you wanted to put this facility back in operation. If it's been sitting for 7 years, I would think that most of the work should probably be done on the 1st and 2nd floor, where people might occupy it. So I would tend to agree with the building inspector and have to rely on his judgment that whether to issue a permit or not, I think I would be relying on his judgment in this particular instance.
Peter, if you wanted to respond to any of that, I think now would be a good time.
Yeah, just so you're clear, what I'm asking the board to do is overturn the denial, order the building inspector to issue the permit. We'll do that work, and then we'll come back and finish the remainder of the work. My clients don't want to abandon this use, this prior non-conforming motel use. They want to sell this property, and they want to preserve the value of this property, and that may involve keeping the motel use. Prospective buyer may want to purchase it as a motel rather than purchase it and tear it down and do something else. So ultimately, that's what we're trying to do. We're trying to cure the violations and get this property in a posture where it can be sold as either a motel or a something else.
It seems the problem is you're not curing all the violations, though.
With this building permit application, I understand that.
Okay.
I don't think there's any questions that there's some issues that will need to be addressed on the other two floors.
Mr. Chairman, can I make one more statement or comment?
Sure.
One of the things we did ask for when we initially walked through on the first building permit application that was withdrawn was a Chapter 34 code review. It's really a international existing building code review on the building based on the work that was to be performed to bring it back into code. The permit was not denied based on this time. It was solely denied based on zoning. But, that's also a document that they had, looking at my notes on the date that we went out to inspect, which would have been the 26th of, is that 16 or 17? I'm sorry,
Patrick, was it 19? 4/26/19?
19. On the first 19. Thank you, Attorney Nectum. That document was never provided and never submitted. We did meet the architects out there that day. So, this also goes to if they were making a good faith effort to get this building up and running and they weren't simply abandoning it to concentrate on the other four, that document would at least exist and been submitted. And just, and so everyone's clear, nothing was denied based on the building code because the Building Code Board of Appeals will not hear an appeal unless the zoning is squared away and in place first. So the process has been working with the board not to write that denial letter until zoning is all set because it will cause a timeline issue for the appellant because his zoning wasn't taken care of. So it's really not fair to the applicant to deny him for both up front because the board won't hear their building code appeal.
So Scott, if we uphold your decision, is there anything stopping them from doing any kind of work to bring things up to code?
Well, in my opinion, we actually have a very generous zoning bylaw, in my opinion, when it comes to non-conforming uses and abandoned non-conforming uses, where it allows this board at a public hearing to issue a special permit and reinstate the non-conforming use. My personal opinion is a lot of city and towns don't have that and you're starting from scratch. I think ours is pretty generous and I believe I got a lot of paper on my desk right now, but without having the denial letter out, I believe I actually cited that section that they could apply for the special permit to reinstate the non-conforming use.
Thanks, Scott.
Thank you, Mr.
Attorney
Chairman.
Nectum, did you have anything else you wanted to add?
No, not particularly. I mean, I think I've laid out our position on what we've done. No, I think that the real issue here is the 2-year period of non-use as opposed to the abandonment portion. I think that there's enough evidence there that there's been no intent to abandon the use. But the 2-year the 2-year period of non-use will be the issue. We think we've done enough based on the case that I cited, but that as Attorney Taylorman said, it's a fact issue specific to each case, and it'll be decided that way if it goes any further.
Thank you. So you make an interesting case on the abandonment. And I think Attorney Taylorman is even said as much, that it could theoretically go each way, and that's fine. What's up with these other violations, though? Like, how can you honestly expect us to back you and say that you should go ahead with doing these renovations to the property and just ignore the other violations with no assurances whatsoever that you will cure those violations?
If my client is going to wants to preserve the use and go through with that, then they're going to have to make those renovations. I mean, they can't just not make those renovations.
Right, but why are we putting the cart before the horse? If you have all these violations that have to be cured contemporaneously to any other work that's being done, why would we approve one building permit that does all the other work while ignoring the violations that are still there? It seems to me you need a comprehensive building permit that will cover everything, and that's what should be presented to the building inspector. I understand that your clients want to just dump this property, and the more approvals they get, the better for value. That's fine, but you still have these violations, and that is still one of there were 2 conditions for his denial, and the first one, you've made a compelling argument. I haven't heard a single argument that says we should allow you to continue with the other violations without anything that shows you're going to cure them.
What I was trying to say with regard to that is that I understand what the October of I think it was October 3rd, 2016 building inspector's order says. And that's that all of the violations need to be addressed. In Judge Howe's decision, her judgment, she doesn't, I still don't agree that she affirms that order. I mean, with respect to the 54 units, yes, but there's nothing in that judgment that says that all of the renovations or remediations had to be done at once, and that's what and I don't see a provision in the bylaw that in your zoning bylaw that says that either. That's what I was trying to get at with that portion of my argument.
Mr. Chairman, could I ask a question?
You may.
Just relative to what you just said, Attorney. And if there's a violation in place, why wouldn't that violation be remedied without haste? Why would you just kind of put them off?
Well, financial reasons for one. I mean, I know you. I think you understand. My client's had a number of projects that they're trying to do, and they've only got so much resources to address to one project at a time.
Well, I mean, maybe they should pick one and get it to the end. That kind of thing. And the other thing too, you had mentioned that they may want to market the property as a motel. Or sell it as a motel. And I guess my argument there would be, how are you going to sell a motel and how are you going to market it if it's in disrepair and has violations, I guess. So these are just questions I'm kind of rolling around in my head. I don't expect you to give me an answer on that, but this is kind of where I'm at with this, and I agree with the chairman that while in your first argument there may be some credibility to that, and again that may be left to the court. The second one, to just sort of ignore building code violations and things like that. This would be a building open to the public. We have some responsibility to ensure the safety and so on and so forth. So, I think there's some questions here that go unanswered. I don't expect you to have an answer for them tonight.
Mr. Chairman, can I address the section of the zoning that Attorney Nectum questioned, not allowing the issue of the permit?
Yes, sir.
Okay. In our zoning, chapter 235, section 9.1.3.2 specifically says, under approval, building commissioner shall approve no applications of any kind or plans or specifications or intended uses which are not in all respects in conformity with these bylaws, unless the applicant has secured a special permit, variance, or comprehensive permit from the Board of Appeals. So my take on this is we're not even talking building code violations at this hearing. This is that's a different board, and that'll be a different time. That not addressing the overage of the 54 units is a zoning violation. And 9132 is the applicable section to deny it, which once again brings us back to the very first permit that was denied after the fire, in the very first trial that was upheld by the judge. So.
Mr. Chairman, can I add it as well, kind of on a related point, because I want to tether these two issues together a little bit.
Please do.
I think Scott's point is well taken, that he doesn't view it as little bits and pieces. If the whole is not fixed, then he doesn't feel that he could grant a partial on any particular work over there. And I think that's sound reasoning based upon that interpretation of the bylaw. I actually think that there's also an argument that seeking a permit for only a portion of this is actually evidence of Scott's conclusions in general that there's been non-use. And because you couldn't save, if you had a huge building, you couldn't save essentially yourself from an abandonment question for doing a tiny portion of it. I think this kind of supports Scott's notion, and again, I defer to the board, however you want to come out on the question of non-use, that if you're not going to fix this thing, if you're just going to take a little piece of it and fix it a little bit just so you can get under that 2-year wire, but still leave all this other stuff unaddressed, you're still not using the property. You're essentially just, it becomes a little bit more of a red herring. That you're using as a means by which you could defeat an argument of non-use, while not really using the property. It's death by 1,000 cuts, so to speak, where you would be, okay, I'll fix this, and then I'll wait a couple of years and I'll fix this, and then maybe I'll apply for a permit, and then maybe I'll withdraw that permit. Is that really use of a property? Or is that just slowly chipping away at a pre-existing non-conforming use, the retirement of which is essentially preferred under the case law? So again, I think you could find reasoning on both sides, but I think another way to view this kind of partial building permit analysis, which Scott finds support in elsewhere, is to view it as supporting the non-use question as well. Food for thought.
Thank you, sir. Any other board comments or questions? Seeing none, I will close the public hearing. I'm going to make a motion that the board uphold the building inspector's denial of the building permit. Building application number C20-000071. Do I have a second?
So, well, actually, I'll move it. So moved.
Second? Ann, unmute.
I'm not.
Sorry, I'll second it.
Vote.
Rich,
Yes.
Greg,
Yes.
Ann,
Yes.
I'll vote yes.
Thank you, guys. Good luck.
Okay, thank you.
Thank you.
I see we have 3 more items now on the agenda. Are the applicants for 17 Sharpness Pond Road here? At this time, we'll open up the 15 Sharpness Pond Road. And Cody, could you read the public hearing notice for permit 21-1111?
I can. The zoning board of appeals to hold a public hearing 7 p.m. March 25th, 2021 with a virtual meeting on the application of Kenworth of Southeast New England, Inc. for the permits necessary to allow motor vehicle light, service, or repair establishment and associated outdoor equipment and truck storage area. The proposal is located at 15 Sharpness Pond Road, found on Assessor's Map 9, parcels 24, 36, and 37, plans on file with the town clerk. And the abutters looks like they've been notified.
Is there anyone here to speak in favor of the applicant?
Yes, Mr. Chairman, Jill Mann here on behalf of Kenworth of Southeast New England Incorporated. I don't know, and I can't really tell if Mr. Dentino is also present. He is the principal of the entity that is seeking the permit, Kenworth. If I may, I'm going to show you, actually, Katrina has up a colored plan, but what I prefer to show you initially is locus plan. And what that'll just allow me to do is just give you the general overview so that you know exactly where the property is and where the building is going to be oriented. So I'm just going to, here we go. Perfect. Thank you very much, Ms. O'Leary. I appreciate that. So as you can see, this particular property is all outlined in gray. What's interesting about it is if you can see that hash line with the dot, that marks where Middleton and North Andover come together. So this property actually has some elements of it in North Andover and some in Middleton. The total property actually has 7 current buildings. 3 are in North Andover, 4 are in Middleton. And if I may, I think I can grab the hand, which I'm going to do. You can see A, C, and then this building right here is a very small building that actually fronts on 114, is also all in North Andover. So all in the gray is the property that we're speaking of. So this building, building E, is what you, in 2018. And at this time, we actually have, so Nomad was the original proponent of the construction of building E. And now we have secured a tenant, which is Kenworth, and Kenworth is interested in collaborating with Nomad to construct the building. And now, if I may, I'm going to show you this color site plan, and then I'll go into the details. It doesn't want me to move. Thanks, Katrina. Yeah, it likes it when you do it much better than I. You have more of a fast control. Thank you. So what you see before you is the current proposal for building E. Originally, what you had proposed was a 55,000 square foot building. We've reduced the scope of the building to about 44,000, so reduced it by about 11,000 square feet. The reason for the reduction is because Kenworth needs more room to get around the building. And now let me tell you the use. So the use is a Class 1 heavy truck dealership. And by the way, I did receive approval from the Board of Selectmen for that Class 1 license at the March 23rd hearing on Wednesday of this week. So basically, Kenworth is going to build this out, and what they will do is they will actually operate a dealership for Kenworth vehicles. Kenworth is PACCAR, and they're like one of the top 6 manufacturers of heavy duty truck vehicles. So sell tractor trailers, cement trucks, dump trucks, heavy duty big trucks. And that's what the dealership involves. So they wanted to take only 33,000 square feet of the building, which you see in brown here. And that's, they're represented as tenant 1. And then the remaining portion of the building, which is tenant 2, is going to be available for the for Nomad to lease to other independent third parties. So as you can see, Kenworth reduced the size of the building both ways in order to have a better flow around the entire building. The purpose of that is clearly to enable them to have their trucks to get all the way around the building. What we were required to do for the Class 1 license is identify what the sales area are. Now, what we had done though for our application before this board was to identify them as storage area, because parking is, we all know what parking is, right? Coming in, parking, but it's not a permanent situation or a situation that's longer than, you know, an entire day or 2 days. So we called any space in which there would be a vehicle stored, waiting to be picked up for purchase. The site plan, we identified that 29,000 square foot area. Oh, my computer's about to die. I apologize for that too. Okay, this Zoom stuff is killing me. So basically, that's what you see. So when you see all around the building, if we meander about, you see employee parking. Then you see sales and storage lots, and you see that coming all the way around the building. Whenever you see storage, that just means simply it's going to be storage. When you see the actual, when you see just storage and sales, that's where there'll be trucks that will be put up. There is a motor vehicle component. And now you can see the trailer stands behind. I didn't know what the heck that was, but what I was told is they sell tractor trailers. So if somebody comes in and they have a problem, they bring it in with their trailer, and then they literally drop their trailers here, dislodge them, and then bring only the motorized portion into the building, because you couldn't fit the big tractor trailers in. And that's really what it is. So basically, the request that we're seeking this evening is to allow a modification of the existing site plan to do two things: to allow for the reduction of the building, to redesign the flow around the building, which would include identifying those outdoor storage areas, which are about 29,000 square feet. And then we are requesting two special permits, one to allow outdoor storage, and then one to allow motor vehicle repair. And that's basically the request in a nutshell. And what we did do, because Mr. Benevento asked us to do this, is we did provide a traffic generation report. So while this all the activity never on 114, the entrance is on Sharpner's Pond, we did want to provide you with what could be the maximum amount of traffic generated by this site. And it will have somewhere around 25, maybe 29 employees. So we're estimating that the total number of vehicle trips, round trip in and out, would be about 126 between customers, employees, and then just what ifs. So under the IT table, I think that's what they call it, the IT table, with which Mr. Sparagis from Williams and Sparagis prepared, and we submitted to this board. I'm just trying to think of anything else. I mean, that is basically the request in a nutshell. It's actually a reduction, and it doesn't impact any of the other areas of the park, because we did limit any of the use to that existing footprint. We didn't expand it at all. We simply used what we already had. And that's it. And if anybody would have any questions, we would love to entertain them.
Thank you, Attorney Mann. Is there anyone else here to speak in favor of the applicant? Seeing none, Madam Clerk, do we have any correspondence?
Okay, this one is from the Planning Board dated March 11th regarding 15 Sharpner's Pond Road. At the March 10th, 21 meeting of the Planning Board, the members unanimously voted to make a positive recommendation to the Zoning Board of Appeals on the application from NOMID Trust for a modified site plan to accommodate the modifications to the layout, traffic circulation, and parking areas for Building E to allow Kenworth of Southeast New England Inc. to conduct sales, associate maintenance, and repair of new heavy-duty trucks and tractors. From Electric Light, 15 Sharpner's Pond Road, Meld has been in touch with Mr. DeGrazia. There is infrastructure that Meld will need to be installed at the owner's expense. From Derek Fullerton, Board of Health, 15 Sharpner's Pond Road, engineer will need to provide septic flow capacity spreadsheet prior to the building permit sign-off by the health department. The engineer has verbally indicated before the development review group that there is sufficient capacity. And Paul Goodwin. For 15 Sharpness Pond Road, I suggest that Tony and contractor owner meet on the site to ensure nothing planned will interfere with the water main. We are unsure at this time exactly where exactly it is at this location. We believe we can find it, but it may be good to meet on the site.
And that's it. I'm
Thank you.
sorry. They did appear before the ICDRC. I had
Right.
problems with Paul Richardson getting copies of that, but I know that they approved both projects before you tonight with I think no comments.
That
Okay.
is correct, Ms. O'Leary. I apologize. I should have mentioned that. I'm sorry.
Thank you both. Katrina, do you have anything else to add?
I do not.
Then I'll open it up for testimony from the public. If you would like to speak in regards to this application, if you could just raise your hand. I see one. And if you could just identify yourself, if possible.
Hi.
There we go.
There we go. Hi. The comment that I have, I didn't see anything about this coming through. We live in Oak Ridge Village, and I didn't see anything come through about authorizing the sales aspect of it. I'm presuming that happened a while back. But where I live, there are two things that I'm concerned about. One is any increased noise, that beeping of trucks that occurs on the other place that's on 114, abutting this building, Middleton Supply, is maddening, okay? Maddening. And so I'm anticipating there's going to be some maddening noise coming from this site, and even though it's sales focused. And then secondly, Shopness Pond Road, a woman passed away there when there was an accident last summer. So even increasing it by one car per day, it's hazardous enough taking my life in my hands when I pull out of where I live. So that 129 cars, and God knows how many of those are going to be tractor trailers that aren't tiny. I'm really concerned about that. Very concerned. I'm surprised that hadn't been raised before. That's it. I'm Janet Daly, 22 Harvest Drive, Unit 310, and I'm available if you have additional questions.
Thank you, ma'am.
You're welcome. Feedback, please?
Attorney Mann, did you have anything?
I mean, this particular use is actually a reduction in what is permitted by right at this location.
But that doesn't matter. Listening to the noise, I'm sorry, the noise at night, again, I don't know what the hours are because that wasn't specified, but I'm going to presume it's even 9 to 5. Well, 9 to 5 is noise. I don't need any more noise. And secondly, the traffic hazard. So it's not right.
Thank you, ma'am. Anyone else here to speak from the public? I don't see any other hands up. Being none, I will open it up for board discussion.
Just want to go right to me.
It's easier.
Okay, just a couple of things. So I went and
Hello.
Whoa,
I'm sorry. I didn't get a chance to speak because my Zoom was not working. My name is Carol Daly. I live in Oak Ridge Village, right in North Andover, which abuts Sharpness Pond Road. And I was a witness last summer to a death in front of me because the people were not stopping at the end of Sharpness Pond Road and just zooming right into 114, and she zoomed right into the lane in front of me. So any increase in traffic without any kind of a traffic light provided by the person who wants to build, occupy, sell, repair, whatever they need to do, they need to do. And obviously they've already been granted a building permit. So I don't really, I'm a mouse here, but I as a living member of North Andover, I would not, I would not allow this if I could, if I were God, without a traffic light there. We need a 4-way traffic light because there are literally hundreds of cars that go in and out of that street where Little Children's Sprouts is on the corner. there's hundreds of cars that go in and out, plus another 128 workers? Is that the deal?
No, ma'am, but we will take that under advisement. Thank you so much.
So you really don't care? I feel like I'm getting blown off.
No, you've been
Need to
given an
let us
opportunity to speak at the public hearing, and that's what we gave you the opportunity to do.
Okay, so I'm noted, and see you later. Okay,
Yes, ma'am.
okay, thank you.
Rich, I believe you were speaking.
Yes, yes, and may discuss some of the things that Ms. Daly and others have spoken about. So anyhow, I reviewed the site. One of my concerns, because it was tractor trailers and so forth, was things like site distance and driveway access and those sorts of things. And I did review those, and it seems that there's already sort of that use going on with tractor trailers. I have a couple of questions relative to. One was the woman brought up about noise, and that would be truck idling. And would we be considering to restrict the hours for truck idling? And the other thing was restricting the term outside storage to the permitted use, because outside storage is like, I like food. Okay. So outside storage, in my opinion, would be relative to the use that's being permitted. So it's going to be trucks and it's going to be trailers. That's it. Now, I do want to talk about the traffic component of this thing. I think we're getting better. And to Mr. Sparagis's credit, he has provided some traffic data, but that is by no means a traffic study. Just taking volumes out of the trip generation manual does not give us a clear indication of what the traffic is. Now, having said that, I think by reducing the size of the building and the intended use, this is not like it's, a fast food restaurant or a McDonald's drive-through. So I get it that we're not going to be really providing or increasing the traffic in any large measure. However, as I said, I think we're making progress, but in the future, particularly on significant projects, a traffic study needs to include existing conditions, study area, roadways and intersections, traffic count data like ATRs, automatic traffic recorder counts, manual turning movement counts, pedestrian bicycles, and then future conditions, traffic growth rate, additional generated traffic, even from new and proposed developments in the project area, generated traffic distribution. You see where I'm going with this. This is, Chris, and I think you'd agree, this is not a traffic impact and access study. I know you've seen those. Accident analysis, capacity analysis, methodology and approach to signal warrants, level of service, VT ratios, queue lengths, things like that. So I can appreciate that we're making progress and you've provided some traffic information, but just taking the numbers out of the ITE trip generation manual is not a traffic study. It's not a traffic analysis. It tells us nothing. All it tells is what the building could generate in terms of traffic. So in addition to things like site distance, and that's why I reviewed this myself. I didn't actually do site distance calculations, but the sight lines appeared, at least to me, to meet a standard that people can see vehicles exiting and entering. One other thing that I noticed that you had in your report was you mentioned Mass DOT, and I'm a little confused because in the shaded area of the site plan, the driveway does not exit onto 114, and based on the shaded area also did not abut Route 114. But does the entire parcel, and Chris, maybe you can answer this, does the entire parcel abut 114?
A portion of the parcel does abut 114. That's
Okay.
why we included that analysis.
Okay.
A very small piece, and there's no in and out, but
Right.
technically we would get sucked in because it's
Right.
it touches
Indirect
the
access.
highway.
Yeah, it's indirect access permit you need. Okay, and so I appreciate you putting that in there. So again, just my comments just relative to traffic. I don't think it's a big traffic generator, but moving forward, if we're going to be submitting traffic information, it needs to be a full-fledged traffic impact and access study. It can't just be trip generation out of the manual. Okay, that's all I have, Mr. Chairman.
Mr. Chair, can I respond to that comment?
You may.
I just want to make it clear that in the past, on projects that were at signalized intersections where we were creating new driveway cuts, where it was a major project, the ZBA has required full, traffic impact analysis. We don't do that work at our office, but the board in the past has required those studies. And it's not like we don't submit that information when it's appropriate. Most of the projects that we do, when we appear in front of you are not large enough to really warrant, to spend that kind of money. But we're happy to do a simple analysis of trip generation and that sort of thing. But if the conditions warrant it and we're near a signalized intersection and it's a big traffic generator, that's a different story. And I agree with you, Rich. And the board has required traffic impact studies in the past. I'm sure they'll continue to ask for them when when it's necessary.
And I think in this case, it's clear that this would not necessarily warrant that. And then there's other cases where it'll be pretty obvious. And then there's going to be those gray areas where I would suggest that we get a determination either from the planning department, or the planning department can reach out to members of this board and feel if they're going to need that information in order to make an adequate judgment.
Sure, we look at these projects on a case-by-case basis, and we're happy to talk to the board about things like that. That's not a problem.
Excellent. Thank you. That's all I have, Mr. Chairman.
Any other comments or questions from the board?
Anybody address the noise issue?
Did you have specific questions, Ann, you wanted to ask Attorney Mann?
I was just asking about the noise issue, whether they're going to address that, about trucks backing up or things like that. What hours are we keeping here?
If you go back, Mr. Chairman, Chris Sporadis again, if you go back to the overall index plan, it gives you a pretty good idea of how many buildings, industrial sized buildings, sort of lie between this proposed building and that development across the street in North Andover. There are quite a few buildings between us and the folks that live, along 114 there in that residential development.
It's hundreds and hundreds of feet. I mean, it couldn't even be thousands from building E, Chris.
Yeah, it's about 800 feet building to building. But look at all those buildings in between us and them. It's quite developed, and there is some noise mitigation that's provided by those buildings. And then,
and honestly, if you look, and I know we all do, we drive up and down 114, and I understand the woman's concern, and I feel for her. But you can tell from that plan, and when you're on 114, you can't even see these buildings. You see one building maybe from the rear, but building E most likely won't even be visible. Now I know sound travels differently, but this is a truck dealership. It's not Middleton Supply that's getting, deliveries of mulch and bringing other materials out. It just is simply not that close. They literally abut Middleton Supply. We're across 114 from that particular residence. And you can tell even in the back by looking in that plan. I don't know where the plan went, but you can tell by looking in the back that there's nothing abutting them.
It's almost 1,200 feet from that residential development to the far side of the Kenworth building, where most of their truck movements are going to be happening.
Right, that's where you enter in. Exactly. I knew it's quite a distance. Thank you, Ms. O'Leary. I appreciate it. She's showing the screen now just to demonstrate that.
Do we know what the hours of operation are going to be?
So here you can see, right? I'm going to grab, you can see building E. And then the residential project that is being spoken about is in this area. And here's Middleton Supply. This is Middleton Supply right here. This is at residence. And this is the building we're speaking about this evening. And the heavy use, I don't mean heavy in terms of it's going to be, outrageously burdensome. I meant as far as where our use will be for this unit is all in the back. That's where you saw all those overhead doors and how you get in to have a vehicle be serviced.
So through the chair, do we know what the hours of operation are going to be?
I mean, it's a truck. This whole park's open 24 hours a day. That's just the nature of them. This dealership, they're not open all the time. I mean, I think it's probably, my guess is 6 a.m. Because of the nature of the business, motor vehicle repair. But as I said, the entire park's open 24/7.
What's in there now, Jill?
Sure. It's a brand new building, Ms. Cody, in that one particular building for building E. But otherwise, there's a company called Flame Laminating, which is a manufacturing facility. There's Pool Supply, which is a supply entity, a company. There is.
So in other words, are we adding to it or replacing?
This application, Ms. Cody, is a modification to a plan that the ZBA has already approved, but it is a new building.
Okay, so the businesses that are in there now are going to stay there, and then this one will be in addition,
That's correct.
or no? Correct,
Yes.
okay.
Yeah, new business.
That the uses are very heavy uses, and it's manufacturing, large scale distribution.
Any other comments or questions from the board? Seeing none, I will, let's see. I will entertain a motion for, we should start with findings. Let's see. I will propose that the board make the following findings. That the record demonstrates that the property and all the existing and proposed improvements continue to comply with all the dimensional density, height, parking, and loading requirements. That by approving the modifications and granting the special permit uses, the board will address the community's need to encourage new businesses in town and to support the reasonable efforts of landowners to develop and maintain profitable commercial properties. The property continues to support safe pedestrian vehicular travel and remains unaffected by the special permit uses or modifications. The existing infrastructure and is affected by the modifications, including but not limited to the addition of the outdoor storage area, utilities, waste disposal, drainage, and lighting that addresses the existing needs of the property as well as any new requirements created by the addition of these special permit uses. The special permit uses are consonant with the neighborhood character with similar uses located in close proximity to the industrial park. There continue to be measures in place to protect the natural environment as confirmed by the conservation agent. And the special permit uses will provide an economic and fiscal benefits to the town by occupying currently vacant commercial space, creating new jobs, supporting new businesses that create additional personal property tax revenue. Do I have a motion to accept those findings?
Before I move that, Mr. Chairman, at what point are we discussing conditions?
Next.
So moved.
Second,
I'll second it.
vote.
Rich,
Yes.
Craig,
Yes.
Ann,
Yes.
I'll vote yes.
Based on those findings, I will entertain a motion to approve. Make sure I got them all. And to approve the special permits. Let me see if I get them all right. Special permit under section 9.4 and 3.1.2 in the table of use regulations under C commercial 10 motor vehicle light service or repair establishment, authorizing the undertaking of service, maintenance, and repairs of motor vehicles in the afore described building E. And we're doing both together, special permit under 9.4 and 3.1.2 and the table of use regulations C commercial 20 contracting and equipment storage yard, authorizing the outdoor equipment and truck storage area consisting of 29,300 square feet located adjacent to building E with the following conditions. First, that the facility be maintained in a clean and sanitary manner and shall comply with all applicable health, safety, and sanitation codes and standards promulgated by the town's building, wire, plumbing, health, and fire inspectors. Two, that all repairs work shall be made within the building and shall not be undertaken in the outdoor storage area. The outdoor storage area shall be used only to park and store vehicles and equipment. Petitioner shall conduct all work within the facility. Petitioner shall not permit any outdoor storage of junk or inoperable vehicles, not including trailers, which which may be on the property, right? Oh, how am I gonna?
Yeah, so there'll be trailers, like when you go in and they'll have, the things that
I'm just trying to
big
think.
round things you put on a cement truck.
Yeah, I'm just trying to think, like, would somebody tab that under inoperable vehicle or junk?
No, you know what? They
wouldn't think
wouldn't,
so.
because you said equipment and that covered it, Mr. Hartwell. So it shouldn't be, there sometimes will be inoperable vehicles though, because it's a repair facility. So I don't, well, I mean, maybe unregistered and inoperable, because they'll be registered. I would as well. Okay, so here's the deal. If you have new vehicles and you're allowed to take a trade-in as an incidental, because sometimes you have to do that, it will only be if there's a trade-in. They don't ever buy from auction and bring vehicles. So it is possible that a vehicle could be inoperable, but it won't be a junk vehicle. I mean, most certainly not. But it's possible that it would need that kind of a repair. If we say not junk, can we then say, I don't know what you'd say.
I mean, the only vehicles, Jill, I think you described it well, as a trade-in vehicle.
It would only be the only time it's a trade-in vehicle or one of their vehicles that are brand new that don't work, a lemon, basically. Ooh, I shouldn't say that out loud, but you know what I mean? There is never a junk vehicle on site, ever.
I think that's an ambiguous term.
I know, I don't know how to
I
say
know.
it.
I don't know either. I'm trying to.
What I was going to suggest that outside storage be restricted to the permitted use, specifically truck or truck trailer combinations. That's what they're going to have there.
Well, you have to have
a concrete.
There will be equipment.
They could be a concrete truck and other similar type vehicles.
And it could be like something they need to be able to adapt. It could be equipment on the back sections, not on those front ones, but in the back, there absolutely could be equipment. But Mr. Benevento, question, if it were to say, you're only going to have the outdoor storage will only be for the storage of equipment and vehicles related to the permitted use. So
Correct.
that way, is that better?
Correct.
If we say that, then I think we cover the concern of the applicant, and I think we address your concern that people don't abuse the outdoor storage.
I have a question while we're talking about this, because the second part of one of my conditions was also going to be that there's no storage of hazardous materials outside. So if it's truck repair, there could be barrels of hydraulic fluid, there could be barrels of oil, there could be all sorts of things, and that should not be stored outside. And I guess if that is the case, and we have trucks there, and there are trucks that are in need of repair and trucks that could be dripping whatever, how are we containing that? Is there some sort of grease trap separator on the oil gas separator on the property that is part of the drainage system? And I see, Scott's still on the call here. How do we handle that?
So all those materials are being handled inside the building, Rich. And inside the building is a series of floor drains that are connected to industrial waste holding tanks. Because vehicles can drive in and drive out of the building, we're required under a separate DP set of regulations to provide industrial waste holding tanks that are double-walled systems with leak detection and high-level alarms.
Right. No, I understand that, Chris. I'm talking about they just towed a vehicle in. They can't bring it in the garage yet because it needs to be worked on. It's parked out in the lot. It's dripping stuff, and then it rains, and that goes into the catch basin. How do we handle that?
I mean, I think as with any instance, they're going to have to resolve it because they're not entitled to do it by law.
Well, that's my concern. We're relying on someone to have to resolve that. Meanwhile, the truck's dripping.
Well, those types of things are handled as an emergency spill, and there are spill kits that are at facilities like this where they pull out a spill kit drum that contains things to suck up like something that might be dripping on the pavement outside, and that's the way they would handle a situation like that. I mean, it's kind of an unusual occurrence.
No, I get it. I understand what you're saying, Chris, and I'm not trying to, belabor this or just, be difficult about this, but this is a reality. And I'm not talking about they pulled in a truck and it was gushing stuff. I'm talking about they pulled in a truck and it's a drip, drip, drip. No one's looking at it. It's not like it's all over the place, but it's in the parking lot. And eventually all that ends up in the catch basin. And then in a drought area, as you know, I mean, you guys do drainage all the time. When it's dry out, all that oil's on the top. And as soon as we get a rainstorm, it's the first flush and all that stuff's going out through the drainage system. So
the answer to your question is that those are considered events that have to be cleaned up immediately. And like with any parking lot that has vehicles in it, we're going to have some oils and greases that naturally might drip off of a vehicle for any particular reason. And that's why we have oil and gas traps, in our deep sump catch basins. But if there's an event, a damaged vehicle that comes in that's obviously dripping, those are events that would be cleaned up, as a specific event, and not be allowed to just sit there. And I don't think they would want that, because those things get tracked into the building, throughout the site. This is a, first class operation.
And in addition to that, and we don't have, this is not a motor vehicle repair facility for junkers. It really is to be associated with its new cars. I mean, I realize you have to consider it, but this is the normal course. This is the way the parking lots are set up. And if there's a spill, we'll address it immediately. And all materials are kept in the building, and we won't store stuff of that nature in those outdoor storage areas. We will not.
Yeah, and again, just to be clear, I'm not talking about a spill. I'm talking about just over time drippings.
Right, but there's nothing's going to be kept out there for long periods of time. This is truly in and out back there. Those vehicles come in, get repaired, and leave.
Well, and again, I'm listening to you both, and you're telling us what we want to hear. The owner is not here to hear any of this. And so we're relying on the fact that what you're saying the owner is going to do. I mean, again, look, I'm not trying to hold this thing up, but I know we can talk all we want about all sorts of things. And then at the end of the day, we're stuck with the permit, right? We're issuing the permit, and then whatever happens, we're stuck with it. That's all. But I'll yield. I'll yield at this point.
Hello? May I?
Please.
With regard to the junk trucks, can we just say no storage of irreparable or abandoned vehicles?
Absolutely.
Does that cover the junk cars that we're all worried about that are going to be sitting out there dripping?
That's a great definition. I didn't think irreparable. And what did you say?
Abandoned vehicles.
Abandoned. Okay.
Well, I mean, going back to the original language that was proposed by the development review group, I mean, so I think what first made me pause is the size of the trucks. But I think the way we've treated this in the past with other auto repair facilities, whether it's big trucks or little trucks, is you can't store junk. Anything that's inoperable, it can't be outside.
Right.
So if it is leaking, it has to be inside.
Go inside, okay.
Because that's why we have all the catch basins inside.
Yeah.
In the floors. And maybe Scott can speak to that a little bit. I mean, that's kind of what we've done in the past, right, Scott? I mean, on Log Bridge, and I think
the most recent one I think was Log Bridge, and that one obviously had the concern of the Ipswich River.
Mm-hmm.
So that one I think doesn't allow any storage outside. I forget how it was worded, but basically damaged cars or anything leaking. But the tanks that Chris Baragis was talking about on the inside, that also falls under the plumbing code. The floor drains ties into the tight tanks. There's I mean, I'm not a plumbing expert, but venting comes back through the building. Could Chris elaborate a little bit on the catch basins and how that separator works on the deep sump? And is there any type of a water quality unit or anything, Chris, before these? I'm assuming it's an underground recharge, just like a Caltech or something.
It is not in this case. We have some land to work with, and so we have open stormwater management areas, and the stormwater is collected in a series of deep sump catch basins, and each of the deep sump catch basins have an oil water separator hood in them. It's like an elbow inside the structure that, and the elbow dives down below the surface of the water, so that oils and greases don't pass through. and onto the system. But if it did, they would next get caught in a sediment trap forebay in the first part of the stormwater management area, and then the last part is the main part of the open stormwater management area. In this case, where it would get caught before it would discharge, and go off to the wetlands. So there's a few, that these are best management practices, and it's a BMP treatment chain of a number of devices, and there's an operation and maintenance plan that talks about checking the deep sump catch basins and cleaning them out periodically, that sort of thing. That's in place and required by DEP stormwater management regulations.
Thanks, Chris.
So circling back, is there an agreement that the petition shall not permit any outdoor storage of junk or inoperable vehicles? Can we kind of rely on that? If you can drive it, it can be outside,
But
basically.
Mr. Chairman, can I inoperable is a very difficult one to interpret on a zoning enforcement, if we were to get a complaint down there.
Mhm.
To me, inoperable is if they have a 5-year-old truck and the motor's gone and they're waiting for Kenworth Corporate or someone to ship a motor for the truck. I mean, that truck is technically inoperable, but it's not, you're talking about a $250,000 truck that's waiting for a $25,000 motor. That's not junk. It's inoperable, but it's not
How
junk.
about irreparable?
There you go. Ms. Snyder's definition, I thought was workable.
And then the other,
So just to circle. So Ann, what would the magic word?
Abandoned and inoperable.
Irreparable abandoned vehicles.
Right.
I don't know if irreparable is a word, but you know what I mean.
It is. Yeah, I do. We'll get
Petition.
it. I understand.
Comes in with a trade-in that is not going to work, and it's just junk. I'm sure they're not they don't want those, but.
So petitioner shall not permit any outdoor storage of irreparable
How about salvage? Salvage.
or salvage vehicles, which is the technical term.
Okay, that's okay. Salvage.
Scott, does that work for you? Salvage?
well, salvage is easy because the titles are branded.
Right, that's what they do with the junk deals. I'm fine with that.
Yeah, and then, Mr. Chairman, I have one more question. When Jill and I first, Attorney Mann and I first discussed this petition, there was some talk that they, in addition to repairs, they might do some upfitting to these trucks. When these trucks come out of Kenworth, it's a cabin chassis, and sometimes they don't have the what they call a flyer kit. They don't have the whole thing's put together.
Yeah.
In the outside storage, Attorney Mann, do we expect to see like dump bodies or a
That's what I had said. We
or a
absolutely will.
flatbed or
That's why
something that's
equipment
waiting
was
to be
very
installed?
important. Yeah, there'll be the backs of
So components of the trucks to be
all
installed.
kinds of stuff like when you have a part that will lift on a tow truck, when you have the circle things for a cement truck, all of those accessories.
So we expect them to store components of trucks.
Yep.
To be installed by the dealer.
Yep. Is that considered part of the equipment?
So, well, I was going to amend that. So I would amend the third condition there to say the outdoor storage area shall be used only to park and store vehicles and related equipment.
Yeah, I mean, I think related.
I mean, we're not just storing like, a backhoe there. We're storing we're storing equipment related to those vehicles,
Yes.
right? So
Yes.
Related to the sales and repair.
Yeah,
right.
exactly.
And lastly, I would add that the petition shall make reasonable accommodations to ensure that noise and fumes generated while working in the bays do not negatively affect neighboring properties. Now,
Absolutely.
anything else that any of the other board members want to add as conditions?
So the condition of saying precisely what can be stored out there would then restrict things like barrels of hydraulic fluid and things like that. Is that right?
Yes. You can store vehicles outside.
I think so.
and
If you wanted
related
to
equipment.
add, no, remember how we did it before, no hazardous materials?
Jill, hang on a second. Mr. Chairman, please, you were saying? I couldn't hear him because I was listening to you. Can you say that again, Craig, please?
I don't even remember what I said. Attorney Mann, were you going to say something?
You said related equipment.
Right. I'm sorry, what was the question, Rich?
I don't know. Let's
All right.
move on.
Other conditions?
Mr. Chairman, I also want to make sure that it doesn't apply to, propane tank and, an outdoor propane tank that, we may need. We have one shown on the plan.
You'd need a permit for that though anyway, wouldn't you?
Yeah, as long as we're not
Yeah.
limited, as long as, not prohibited,
No, I don't think, I mean, that, I wouldn't, well,
That's the way many of these
Yeah,
buildings are. These buildings are, heated by propane in this industrial park, and we'll need one in the back of the building.
do you have a spot on the plan where you're going to put it?
We do.
That's good enough for me. I think that's typically what we've done in the past, haven't we? If I'm not mistaken, that in situations like that where we anticipate there's going to be on-site storage of gases and stuff like that, that we've had the pad kind of laid out where it's going to be on the site. So maybe to that effect, you can point that out on the plans.
Chris, that's permanent too, right?
For the most part, yeah. Once it goes in, it'll be,
Right.
it'll,
Yeah.
and it may even be, they're not sure if they're going to bury it or if it's going to be above ground. We'll see.
Hey, Mr. Chairman, if I could just ask Scott a question. So Scott, based on the conditions that we've just listed, if you went by there and you saw 55-gallon drums out there, based on the conditions we have, you could go knock on the door and say, get rid of those. Is that right?
Yeah. Yeah, and I think it's pretty clear that the hazardous waste or the hazardous material condition is based upon drums of oil, hydraulic fluid, pallets of batteries sitting out there waiting to be picked up. I don't think I'm glad Mr. Sparagus brought it up, but I don't think it's pretty clear it's not the propane tank that's used to supply the propane for the building, because the gas doesn't run down into there, Chris?
It does not. And, the rest of the industrial park is fed by an existing propane tank field. But this building may need its own, and then Mr. DeGrazia is going to have the end of the building, the 11,300 square foot end of the building. There are some users, depending on what an industrial user might need. They may need maybe a CO2 tank or a oxygen tank, outside the building. I wouldn't want to limit those types of things, that people need to run their businesses.
No, but Chris, I think on a new prospective tenant, if they wanted to say add, I don't want to call it tank farm, because I can't imagine many tanks, but one or two.
Right.
You'd be back to modify the site plan approval anyways.
Yeah, I'm not concerned about that, Chris, honestly. Not for something like this. They're trying to limit the outdoor storage for this particular entity, and I get it.
Okay, great.
I get it.
Any other conditions? Seeing none, do I have a motion to accept those? Do I have a motion with those conditions?
So moved.
Do I have a second? And the blank. Seconds. Do we have a vote, Ms. Cody? We lose Ann.
I think so.
She's muted.
I think so.
She's still muted. There she is.
Oh,
Nope, now she's muted again. Yikes.
just give her a minute. She might be having. Oh, there we
She
go.
is.
Can you hear me?
Yeah, no worries.
Am I there?
You are.
Yes.
Oh, yay. Okay. Sorry about that. Okay, Rich, go ahead.
Yes.
Vote.
Yep. Craig. Okay, Craig,
Yes, ma'am.
Ann,
Yes.
all right, and I vote yes.
Thank you very much. We appreciate your time. And I'll update the decision and reflect all of the additional conditions. Thank you and appreciate it.
Did we? Don't you have site plan too?
Yeah, oh, I'm sorry. Yes. I thought we did them all together. We just did the two special
Just
permits.
the two special permits are together. Also, based on those findings, I will propose that the board move to accept the site plan as submitted.
So
Vote.
moved.
Second,
Second.
vote.
Rich,
Yes.
Craig,
Yes.
Ann,
Yes.
I'll vote yes.
Now, thank you very much.
Thank you very much. Ms. Cody, could you read the public notice for 177 North Main Street, please?
All righty. Zoning Board of Appeals will hold a public hearing 7 p.m. March 25th, 2021, virtual meeting on the application of Bay Property Management North LLC for the permits necessary to construct 2 new structures totaling approximately 17,600 square feet, the creation of 2 new outdoor storage areas and accessory parking, the authorization for up to 24 contractor bays with offices, indoor storage, and up to 2,725 square feet of outdoor storage located at 177 North Main Street, found on the Assessor's Map 17, Parcel 51, Map 58, Parcel 650. Plans on file with the town clerk.
Is there anyone here to speak in favor of the application?
Yes, good evening. Jill Mann here on behalf of Bay Property Management North LLC. Also with me this evening is Chris Spragus from Williams and Spragus in support of this application. This particular project, again, is an industrial park at 16.5 acres, and it is subject of a pre-existing site plan approval from 2016. So this is the park. I'm going to, oh, thanks, Katrina. If you wouldn't mind, that'd be great. You're going to tap into the site plan. This particular project had been approved with 5 buildings on it, 4 of which were industrial buildings. Building A, building 200, 400, and then so 200 and 400 are Salem Metal and Regal Fabrics, and then there are 2 buildings in the middle, and those buildings are building 204, I apologize, building 300 and 600. And we also had 1 building in front that was an office building, and that's building 100. And I apologize, it's all these confusing numbers, but that's how it's best for the fire department and the assessor. So we are proposing to add 2 additional structures as a second phase to our project. Originally, we had thought the second phase would be the office building, but this is not a time to build an office building. So that's going to be our final phase. And we are presently seeking to build these 2 new contractor bay buildings. So this particular application also asked for contractor bays in those 2 buildings that are on the interior of the site, which are building 500 and, building 300 and 600. When we originally got them permitted, we weren't sure what types of uses would want to go into this particular office park and whether or not it'd just be one of the by right uses, which are, industrial, manufacturing, distribution, et cetera, because it's an industrial park. But what we have come to find out is that most of the demand is from contractors. And so that is why we are seeking 2 special permits for those buildings to be used as contractor bays. These particular buildings in the back that we're constructing are being constructed with some particular tenants in mind. They are up to 3-unit buildings. They're a 9,600 square foot building and an 8,000 square foot building. The 8,000 square foot building has room for a mezzanine, but presently there isn't one. Both of these buildings will have associated outdoor storage. One of them has about 2,000 square feet and the other one has about 551 as shown on the plans. And I can grab this pointer and show you. So one of the outdoor storage areas is right in this area. And then the other one is I'm having a hard time, is right in this area. So basically, the way you enter into these buildings is around the back. Here are the doors for the building. And in this particular building, they're in front. The area back here, it looks like this is going to be an outdoor storage area. It isn't. It's an area for picnic tables, just for the people who work there to go out and to relax during a break. So that's what this is in the back. The particular buildings are designed with their own parking. So basically each building has 6 parking spaces each, and then there are a total of 4 to be shared as visitor parking if you need it. And that's in addition to the fact that you have parking directly in front of those overhead doors, but we don't count that. We just count the traditional parking spaces. So when we designed this portion of the park, we designed it with an independent stormwater management system and septic system. And obviously, every time we designed and permitted a building, we did so keeping in mind what the individual uses would require in order to be able to provide for sufficient parking every time we designed a building. And that's why I point out the parking individually, because these particular buildings are pretty set. Here's the other building, building 600, and its parking is on the other side. And these buildings just simply have their own independent parking. And that's why I point that out. The particular uses, as I said, are necessary. That's basically what the market is right now. The market is not for office, and it isn't for many manufacturing uses right now. It's predominantly for contractors. So that's what we're trying to satisfy. These particular buildings have all the necessary utilities. They have the septic system there. They have the stormwater. Lighting is fine. Parking is sufficient. It's going to be a very low demand type of use. They definitely meet the criteria for, fiscal benefit to the town, because otherwise there would be no tax value generation. Each of these buildings at that size, as well as just stimulating the economy by having new businesses in town, so more activity and more support for other businesses. As far as the community need, the community need is basically to provide these types of uses. There's a great demand, and we're satisfying that. Based on all of those criteria, we would request that the special permits for those uses be granted. And then with regard to the site plan approval, there are, thank you, Katrina, this is great. So before we even began construction and design of the building, Mr. McKinley had assured this board that he would put up a screen buffer between the residential properties and this particular property, even though those residentials, some shared the border with industrial. And here's just an example of the 20-foot trees that were planted when we said we would, maybe 2 years ago. Maybe a year and a half ago. I think Ms. Snyder, Ms. Cody, I know Mr. Hartwell was on the committee at the time, and all know the history of that and how Mr. McKinley did exactly what he said he was going to do. With regard to the buildings themselves, as I said, they're designed to meet all the setbacks, all the height requirements, and then we did appear before the design review board and before the industrial design review board. So I meant the department review group and then the industrial design review. So during the department review, there really were no comments that, other than questions, really. A couple of questions by the fire chief about how he would access the building, which we showed. A couple of comments by Mr. Fullerton regarding the sewer system, and that was about the septic system. That was about it. But we did receive approval from the design review committee and a unanimous approval also from the planning board. And based on that, I would ask that this board approval to modify the existing and approved site plan. Thank you very much.
Thank you, Attorney Mann. Is there anyone else here to speak in favor of the applicant? Seeing none, Madam Clerk, could you read the correspondence?
Okay, this is from the Planning Board, March 10th, 21. The meeting of the Planning Board members unanimously voted to make a positive recommendation to the Zoning Board of Appeals on the application of Bay Property Management North LLC to permit 2 new buildings, 24 contractor bays with offices and outdoor storage areas, conditional upon the installation of adequate screening No exterior fabrication will take place outside the buildings. From Meld, 177 North Main, there's an existing Meld plant to service this building. From Derek Fullerton, same noise conditions as the other building that Ms. Mann identified, same conditions for noise and odor should apply for interior and exterior for proposed buildings. If possible, the engineering should be explored to see if the contractor base could be flipped to face the front side of the buildings toward North Main Street and not toward Dixie Drive.
And that's it.
Okay.
Are there any comments from Katrina or Scott? Seeing none, I will open it up to public comments. If you would like to make a comment, I ask you please raise your hand. We will then call on you, and then I will open it up for the board members or Attorney Mann to respond.
I did just let Mr. Castro in. I think he has to unmute himself.
Mr. Castro, would you like to go first?
Yes, please, if you don't mind. Vic Castro, 30-year resident at 15 Dixie Drive. So I've been for a long time, and I was here and attended the meetings on the original approval of the project. And anybody remembers, I was one of the few neighbors that actually supported the right to build there and suggested that we could be good neighbors. Well, in the time that it's been there, it hasn't necessarily worked out great. We've had nitrogen deliveries from Salem Metal all hours of the night, waking my family. Dumpsters first thing in the morning, clanging out there. I will give Mr. Vining some credit because he did make some efforts to adjust delivery schedules. We've had a few missteps along the way, but recently he's been better. It's pretty tough in the summer and spring to keep windows open. So while Attorney Mann did say this screening there is no noise screening. So what's happening here is every clang there is coming over. I certainly think it violates the zoning bylaw 543.2 for ambient noise. I mean, I'm 50 yards from Salem Metal, and it's deafening over here when that stuff happens. So while I don't object at all to the buildings, the outdoor storage adjacent to Dixie Drive, is going to be a problem. And these same bylaws that protect their right to build also protect our residents' right to some peace and quiet. So, that's my point. I know you hear noise on every one of these things that comes across. We are direct abutters, like I said, 50 feet. If you look where they want to put one of those outdoor storage areas, it's, just on the corner of Salem Metal. My house is elevated. I look right across the street at the same level. There are no significant berms that absorb the noise. There's a fence and trees, but the noise comes right through. So, again, I respect their rights. I expect, the contributions to the economy, but as a landowner in a residential area, I purchased land next to a light industrial zoning, but they purchased light industrial land next to a residential area. So I think we both have to live by the bylaws of this town. And unfortunately, where they're at directly above residential. I'm not across 114. I'm not several hundred yards away. I'm 100 feet or so from that. So I would ask the board to consider that. Relocate the outdoor storage, restrict its use, but in the types of use they want for those buildings for contractors, you can see heavy equipment out there. I can see heavy metal storage, construction materials that they're going to want to be moving early in the morning to get out to job sites and back and forth. So, that's my piece as a landowner, and want to make you aware that, it's been a problem. I haven't raised a lot. I did reach out to Mr. Fitzpatrick. He did help me to get in contact with Mr. Vining. And again, he was very accommodating. He is paying extra to have deliveries, but the nitrogen tank that delivers for 50 minutes at a shot at 3 o'clock in the morning was not working out too well. And dumpster pickups and delivery at 4:30, 5 o'clock in the morning, where they pick them on the back of the truck and clank them around, waking us up. We have to work too. So, I guess that's kind of what I wanted to share on this stuff. And ask for your consideration on the restrictions, the noise. I don't know if you can restrict hours, make them move it. I don't want to stop, the businesses in town. I know they're good for the town, but, have a right to live in a little bit of peace over here too. So thank you for your time and consideration.
Thank you, Mr. Castro. I see another hand up. Unknown Zoom user. Is there anyone else that's been brought over that would like to speak? You could just raise your hand again once you've kind of been brought over. I just asked that if you're going to speak, if you could just raise your hand again.
I'm trying
and then oh no worries, and just you can just identify yourself.
I'm trying. I'm Deborah Ford from Dixie Drive. Also, Victor said everything I needed. Was going to say. The loud noises in the middle of the night, 3 o'clock in the morning. We're woken up out of a sound sleep with the filling of the tanks. And my other question is another residence being torn down on Dixie Drive? Is that what I'm saying?
I'm not sure. We'll let Attorney Mann respond after we have all the public comments. But
okay.
We'll add it to the list.
But we need to do something about the noise and the new bylaws. Or there's definitely pollution out there with the noise. It's awful in the middle of the night. It's not okay. Thank you.
Thank you. I think I saw another hand possibly.
Mr. Chairman, was there a name and address for the record on that last speaker?
Hopefully.
It's Deborah Ford, Dixie Drive, 17 Dixie Drive.
Okay, thank you.
Mr. Chairman, I think there was a Steve Kahn that had this raised.
Oh, I see his hand up. Yep.
Yeah.
Steve, you're unmuted. If you could just identify yourself.
Okay. Yeah. Hi, I'm Steve Kahn from Regal Fabrics. Sorry, my video was off.
Oh, no worries.
I just question. I couldn't really tell from the plan when it went by, and you mentioned 24 contractor bays. Does that mean 24 additional companies in those 2 buildings? Can you explain? My concern. I'm from Regal Fabrics, and the roads are pretty tight there, and I know when I drive in every morning, if there's a truck there that's working on the buildings that I have to drive by, usually they're sticking out into the road. And there's all kinds of 18-wheelers going through there all the time. So 24 additional contractor bays sounds like a lot more activity there that's going to jam up those roads. Can you just explain what it's going to be?
We're going to let Attorney Mann kind of take all the comments and then respond to them all at once.
Okay.
Thanks. Did you have anything else you wanted to add? Or just
No, I'm just trying to find out what's going on.
Okay. Is there anyone else from the public that would like to make a comment or have a question for the applicant? Seeing none, Attorney Mann, you're up.
Thank you. So I'm just going to take them in order. So with regard to Mr. Castro's issues, it's my understanding that the complaints were related to Salem Metal, and that the owner of Salem Metal had actually reached out and spoken to both the building commissioner, I think, and perhaps Ms. O'Leary as well. It was not as a result of neglect by the building owner. It was a error by the vendor, and it's very unfortunate, and I appreciate the fact that Mr. Castro deserves to have peace and quiet, and that is something that it's my understanding has been corrected. And at the beginning, the building owner from Salem Metal actually paid more to ensure that deliveries would only be during a certain window of time, and that was a very large issue from them, and it supposedly has been taken care of. Not that this particular application, I have to tell you, has nothing to do with the other portions of the building. Those are existing site conditions, and I can't control them. They're all independently owned buildings. This is a condominium, but I still want to address them because I do know about them. Relative to any buildings being torn down, nothing is being torn down. All of the property you see is the property that exists. There's no proposal to raise in order to renovate or to reestablish a building. So no, these buildings are being built on existing land. With regard to the comment about 24 bays, That's because there are two existing buildings that exist in the middle that have 18 bays. Those are already existing. Those buildings are up and built. Those are the two in the middle. We're adding presently 6 contractor bays to this particular area. And those are all of the questions, I believe, Mr. Hartwell.
I believe.
Or answers to all of those questions. Did I miss something?
Are the bays closer to 114 or closer to Dixie Drive?
So they are one of each. So one of the buildings, building 700, has rear facing, oops, now I can't see them at all. Rear facing. So, yep, there you go. Okay, now we're in the wrong you were in the wrong plan.
Wait, I thought because the new plans don't show the 2 buildings that are going to have some of those 24 contractor bays, right? And I know Steve Kahn was
they're permitted and the doors are there. I'm talking about the brand new buildings because that's what we're adding.
So on the new site plan, Katrina, sheet 6 shows the entire site as a survey plan.
Yes, there you go. So there are the 2 buildings. So with regard to your particular question that had just been asked, there are the contractor bay door. The contractor bay doors for building 700 are right here, the 3 of them. And then the contractor bay doors for building 500 are in front. And this is where you have a fairly large topographical change as well as the big stand of trees as well, right, Chris?
That's correct.
So I don't know who asked that question, but did that answer your question?
Well, could I ask how many bays are in each of the new buildings?
3. Each new building has 3.
So
building 700 has 4. There's one that wraps around the corner there.
No, it's 3, Chris. They're each 1, 2, 3 each. There's only 3.
So building 700, there are 4. The building has a little L, and there's a fourth bay on the L.
Not shown.
Yeah, it's there.
I can't see it.
You got to scroll way in, but it's there. It's just not set up as a separate unit on the plan. There's only 2 dashed lines that divide up.
Because, I mean, the intent from my conversation with Mr. McKinley is that this unit 1 is intended to be 1 unit, not 2.
I guess the question I was asking
is
is
mezzanine on one of them. Perhaps that's what's causing confusion as well.
if you're asking for 24 contractors bays, and now you're saying there's either 6 or 7 in the new proposed buildings, where are the other contractor bays?
Again, they're in the existing buildings 200 and 600. I mean, I apologize. I keep doing that. Sorry. Buildings 300 and 600, which are the existing buildings that reside in the middle of the park.
So, right. That's why I was showing the old plans, because we haven't seen yet where those are.
Yeah,
Right,
they're
but the
on
question
sheet
being asked,
6
where
and
the new-
11, Katrina.
But those are not new doors, new buildings. I think they really wanted to know where the new structures were, and I couldn't show them on that plan.
Oh, no, I wanted to know where the special permits are being granted for those contractor bays.
Yep.
And we hadn't seen where they were yet.
Yeah, in the middle, you were right. Those are those 2 buildings in the middle that have been permitted previously. Yes.
Yep, and there is a sheet in the plan set, Katrina, sheet 6 of 11, that shows all of the buildings in the industrial park.
If you get, I know it's buried a little bit, but
Wait a second. If I open this up.
there you go.
There you go, the one that says C6 survey.
Yep.
Does it show how you get into those new buildings? Like, is there?
We're not talking about those yet. Can we? So Katrina, you just 1 second. So Katrina's question, right? It's these buildings and this building are the existing buildings that will be contractor based.
Okay. And so for tonight,
currently, the way you get into them, where the you get into them, Chris. These you get into the overhead doors here and here. That's how it was always designed, because the park goes around in a circle. And then, if I may, please, Mr. Chairman, I'm just going to answer Mr. Khan's question.
Please.
The way you, in fact, get into the other buildings is you drive. I guess you'd either come in this way or you come in this way, and here's the access point right here. To go
Right in
into
the middle, in the middle of the 2.
Yes.
and so for tonight, the board is going to be approving the special permits and the site plan that contains the new buildings and the buildings that you're requesting special permits for, because those include site plan review, right? And so would you say the scope includes the middle portion, but not the two big end buildings?
It does not include the two big end buildings. Those are independently owned, and we don't have authority to control and or modify any approval they have.
So it's really, this is the scope of the site plan that's before the board tonight.
Exactly. The scope
This
of the
area.
site plan is really, I mean, there are no real changes to these buildings at all, but when you ask for special permit, it triggers the site plan review process, basically to ensure, you're providing driving around the whole bit. But I mean, in this particular event, these were kind of set up in a manner to actually have heavier uses than a contractor bay.
So, Mr. Hartwick, can I circle back on Attorney Ann's response to the noise?
You may.
Thank you. So again, as I acknowledged earlier, Mr. Vining did make so much. I can tell you that it happened just last Thursday and he did address it right away and made a call. It's not the issue, but it seems like it's now they're independently owned businesses. It's no longer the developer's issue. Well, when this development was initially approved, it was developed by Bay Development, and so they were granted the approvals on this property. So once they get this in there and they start getting these out, then it becomes somebody else's property. And I just want to point out that the noise things, the 5.4.3.2, there's no time on that. The standard is that they're not supposed to be generating above a 10 dB noise level at the receiving property, which they're doing. But again, I respect them to run their business, so I'm not going to complain 8 to 5, even though working from home it can still be an annoyance. It's tolerable, and what are they going to do now? Tear down the building? So that's the point. But I don't want to push it off like, well, they're only taking deliveries in the middle of the day, so it's not an issue anymore. It's still an issue. It's an issue that they're exceeding the allowable noise level at the residential property. So just want to recognize that when you make your decision on what parts of this to approve or what limitations to put on it. It's not just that, okay, Mr. Vining's paying to have deliveries during certain hours, so that totally mitigates the problem. No, it's more of a compromise. Okay, he satisfied my need to sleep. I satisfy his need to not push the 24 hours and say he can't run his business. So again, I'm trying to be a good neighbor here, and if there's alternatives, I expect that whatever goes on over there, that they're going to be good neighbors, and I'm not going to have to sacrifice my course of living because of it. So again, on the response, it just seemed like that's Salem Meadows' problem now. This is the time to address what they do over there before that becomes a problem too, and it's somebody else's problem. So again, thank you, and I guess that's all I have to say on that subject.
And
Mr. Chairman,
thank you, Mr. Castro.
Mr. Hartwell, may I just respond to one thing?
You may.
It'll be very brief.
Could I take this chance to ask a question?
Please, Katrina, while Jill reboots her.
Right, I actually need her here. Mr. Fullerton, the health director, had mentioned to me that when they permitted the place that cleans sharps, the bio cleaning place down at Logbridge Road, they attached a condition that if there were any noise reports from the neighbors, that the owner would actually have to hire a consultant to come out and measure the noise levels. Mm-hmm. And I'm wondering if the ZBA would consider attaching such a condition so that if we do receive complaints, the town has no way to go out and measure the noise. And so we're always left, we can't do anything unless the board attaches a condition that can stick. And if you put it on the owner to actually hire a consultant to start measuring the noise, first of all, that gives incentive for them to be more quiet. Second of all, we can get the noise measured somehow because we know the town can't do it. And I know Jill knows more about it. I don't know a lot about it.
Yeah, and this is the problem that
let's just hold on 1 second because she's not even here right now. So let's let her give her a chance to get back so she can answer the questions.
And I guess while everyone's quiet, I'll also throw this out there. I did put it in the staff report. The board does have the authority to limit hours. And so that might be something you want to consider, so that if we do hear deliveries happening at 4 o'clock, Scott can go out there and say, no, you can't be doing that before whatever time limitation you put on it, maybe 6 a.m. till 8 p.m. And I don't know what would work for the owner. I don't know if that's too limiting. And so,
Attorney Mann,
unfortunately,
we were just talking noise.
So I just want to, Castro's issue is well heard. I wish, problem is we didn't have any idea this was going to be discussed tonight. This is all needs to be addressed. It really does need to be addressed also by the owner of that building. And I feel bad for Mr. Castro because he wants to voice these concerns, but it's almost not the right way to have done it. If I had known, I would have tried to have somebody here to do that, Mr. Hartwell.
But how are you going to address noise in these 2 new buildings?
Oh, that I can address, Mr.
Well,
Hartwell.
it's all the same issue. So right. So how are we going to mitigate the noise from these 2 buildings?
So these 2 buildings.
I may just real quick. I'm not here to complain about Salem Metal. I think mining has worked with us to do that. What I'm saying is that condition came when they moved in, and I'm trying to prevent it in this new phase before it happens, rather than dealing with it after, because it's inevitable with the types of occupants that they're going to have with outdoor storage, that noise level is going to get beyond what's allowable there. That's what it is. So this isn't about Salem Metal because they're there already. And again, I think we've worked the compromise there, but we have the chance here to assess what proposed use is for these new buildings. And I just can't see the type of use to have outdoor storage not to generate that kind of noise. And given, the hours of operation for those businesses, it's inevitable that it's going to be early morning drop-off pickup of heavy equipment and supplies. And it's going to happen. And then I'm going to be a nuisance on the town calling all the time about being woken up in the middle of the night. So
yeah, I mean, we can, with regard to these buildings, as we do with, other contractor, but it's just because we keep talking about Vining, which is why I keep saying it. So when we talk about these contractor bays, though, what we can say is, look, there's not going to be any use outside of the base. That, the use of the outdoor storage is purely passive. We can limit the time for deliveries to be, during reasonable hours. That's fine. I mean, I think that the issues, that are attendant to the other building are issues, and we can provide some protections like that. These particular buildings are much farther away in that circumstance, but I understand. And that's how we could handle it, Mr. Hartwell.
You're saying these buildings are further away from the residences?
Then if you see them, they're like, you can tell where they're closer to Middleton Industrial Park. This particular person is right here. There is a resident right here. He's actually reviewed the plans. And here's where Mr. Castro lives.
Oh,
Oh, I apologize. I'm so sorry.
Now you can grab the hand.
And I shouldn't. Right. So here's where Mr. Castro lives. And here's the Vining building. And then here's the 2 new buildings.
Right, but those buildings are directly abutting the residential properties. They're not it's not like you're putting 2 contractor yards on the 114 side.
No, we're not. We're putting them here.
As close as humanly possible to the residential boundary.
I mean, we put them, it's, they're the distance they have.
Could it go any closer to the residential district than you put it?
No, not under the code. No.
Right. Okay.
No.
I would like a site walk. So
That's fine.
I'm gonna,
I understand.
I don't know if the rest of the board has any interest in that, but.
Yes.
Oh, absolutely, absolutely.
So why don't we schedule that?
Sure.
We'll plan to continue this till the next meeting, and we can revisit after we've had a chance to see the actual site. As usual with a site walk like this, Chris, get your sticks ready. So
Yep.
the whole, and I want all the boundaries of the building laid out. I want driveways laid out.
Sure.
There's
Parking, the
no-
contractor area, the storage.
everything.
Yep.
Color coded. Go to town. It's got to be crystal clear.
No problem. We will do that.
Yep, no problem at all.
And it appears that your neighbors are unaware of some of the plans that you're working on. So maybe we can invite them to the site plan as well, Mr. Khan. Just like any other abutter or would be allowed to come to the sidewalk, not ask questions during the sidewalk, but it gives them opportunity to see where the stakes are and what the patterns are going to be. So
Yeah, that would be great. Thank you.
Mr. Chairman?
Yes, sir.
Are the members going to have an opportunity to ask a couple of questions? I've been waiting patiently.
Oh, you mean tonight or at the sidewalk?
No, right now.
Oh, sure. Yeah.
Thank you. Thank you. Unless there's other members of the public, I'll yield.
I don't see any hands up, so you're on deck.
All right. Thank you. So just a couple of questions. First of all, I agree that I would not be ready to vote on this evening and agree with the chairman that we need to have a site walk. So I'm all in favor of that. Just a couple of things, just so I have some context of this project. First of all, are these condominium units up there? These buildings, well, let me rephrase that. Is this an association of some sort where they pay dues or something like that? Or is it just
a condominium?
Okay, so if there are individual property owners, you could appeal to the individual property owners, but you also may appeal to the condominium association relative to noise and things like that. Is that right?
You can.
Okay. Okay, so with that, these opportunities always present another bite at the apple, if you will. Okay, so if there are noise issues, we may not necessarily just be focusing on the two buildings that are before us, but we're looking at the entire property because it's a condominium association. And I know Mr. McKinley does great work. I'm in awe of some of the things he's done around the town. I think he does quality work. And it may be something, and again, until I do the site walk, I'll have a better judgment. But, I think planting trees is one thing, but he may want to put up some type of physical barrier like stockade fencing of some sort just to block noise. Again, once I get to the site, I'll have a better idea of how that might work. The other thing I just had a question about, so the original project was about 190,000 square feet of buildings. Is that right?
I don't recall it's about that.
Yeah, okay. And maybe Chris might know this. Chris, did this require a MIPA filing?
We did not file with MIPA.
Okay. And did you obtain a permit from Mass DOT?
We did.
Okay. Is that permit available? Could we get that between now and our next meeting? Could I get a copy of that?
Sure.
Okay, awesome. The reason I asked that is this is going to be additional trucks. And I know, thank you, Chris, for providing some additional ITE trip generation information. But a project like this, because it's an industrial use, contractor equipment, so on and so forth, I'm more concerned about truck trips than I would be vehicle trips, right? And Mr. Khan had already mentioned about, circulation and conflicts with circulation within the site. I'd also be concerned with, obviously, site distance and access to 114 out of the property, particularly with tractor trailers and things like that. So those are the kind of things I'm presuming. Chris, did you guys do the original site plan for the original project?
We did.
Okay, and part of the Mass DOT permit, I'm presuming you had to show truck turning onto 114 and that sort of thing. Is that right?
That's correct.
Okay, so would it be possible to at least see some of that information as well, those existing plans, because that would give me a better feel for if we're adding more trucks and more turning movements and things like that, that whatever's there right now, and I'm presuming if Mass DOT approved it, I'm okay with it, but just to ensure that we have proper access and egress for tractor trailers and things of that nature.
Sure. Our site plan submittal for this new phase of the project does show, the edge of pavement and curbing that was constructed. It's shown on sheet 6 of 11.
Right.
Is there anything else that you would need other than that, or?
I was just interested to see the original plan where you actually had truck turning templates on those plans. I'm presuming that you had to give them to Mass DOT. So you probably have them in the folder someplace. I'd just like to see them. That's all.
Okay, I'll take a look and see what we have.
Okay. And that's all I have. Looking forward to the site visit.
Before we vote on the site walk, is there any other board members? Are there any other board members that would like to ask questions, make comments at this time, or we can hold them over till after the site walk?
Just real quick, I know Dixie Drive is in proximity. What's to the right of the building on the right? What residential homes are over to the right there?
If I may, Ms. Cody, here,
Correct?
that's Middleton Industrial Park. It's all industrial uses. Then down here
Right.
are homes on 114. But up back here near the new buildings is Middleton Industrial Park.
Okay.
Anybody have a preference for a site walk date?
At the pleasure of the board.
When it's warm and sunny out.
This is New England, Mr. Benevento.
We could do midweek. We could do during the week now where it's daylight later.
Yeah.
Instead of the weekend.
How about April 7th?
Okay.
To Wednesday?
Okay.
Want to do like 6 o'clock?
Perfect.
Perfect.
All right. Wednesday sidewalk.
6 p.m. Is that it?
Yes, 6 p.m. sidewalk.
April 6th.
April 7th, the Wednesday.
Yep.
1 second.
Mr. Chairman, you need a motion to continue?
In a second. Is there a motion to continue?
So moved.
Oh, hello.
To April, what? I'm sorry, when is the motion to what's the date?
So the site walk is scheduled. So I'll make a motion to conduct a site walk on April 7th at 6 p.m. That is a Wednesday evening.
So moved.
Second,
I'll second it.
and vote.
Rich,
Yep.
Craig,
Yes.
Ann,
Yes.
I'll vote yes.
And make a motion to continue to the April meeting.
So moved.
Second,
Second.
vote.
Rich,
Yes.
Ann,
Yes.
Craig,
Yes.
I apologize,
I'll vote
Ms.
yes.
Hartwell, but for the benefit of the public, what is that date?
April 22nd.
April 7th.
Yes.
April 22nd. I apologize for the interruption. Thank you.
No worries. Yep, that'll be April 22nd.
At 7 o'clock.
Yep. And
Thank
vote.
you.
Rich,
Yes.
Craig,
Yes.
Ann,
Yes.
I'll vote yes.
Thank
All
you.
right. Thanks.
We'll see you on the 7th at 6 p.m.
All right. Last but not least, we have 9 Hilldale Avenue. Are the applicants available? Attorney Mann, are you representing them?
Yes.
Okay, so we don't have to. Do they want
We
to
have to
speak
open
to?
it?
Should we make them panelists?
Sure. The Moderatos, if they're there, that'd be wonderful.
Do you want me to open it?
Yep. Go ahead, Madam Clerk.
Okay. Zoning Board of Appeals will hold a hearing at 7 p.m. March 25th, 21 on virtual meeting at the application of Carmine and Ashley Matarazzo for the permits necessary to alter a pre-existing non-conforming single-family and an accessory structure by adding a second story and expanding a front entry into the front yard setback. The proposal is located at 9 Hilldale Ave, found in Assessor's Map 32, parcel 99, plans on file with the town clerk.
Is there anyone here to speak in favor of the application?
Well, good evening. Jill Mann here on behalf of Carmen and Ashley Marazzo. They are newcomers to Middleton. They bought their home in 2019 and it's located at 9 Hilldale. So
We heard it. It's on record. Don't worry.
So this is one of those very old properties. It actually is, there's 3 of them combined to form a 9,000 square foot lot. The home is 1,800 square feet total. It's a 3-bedroom. It's a 2-story structure. It has a detached 2-car garage. And the proposal is simply to make it nicer. I mean, they want to add a 2nd story to the garage and they want to continue to improve the home. And I would love to show you pictures of it because, so here's what they're proposing to do. But I think if I'm trying to, Katrina, you don't remember where the actual pictures are, right? The photographs, I think it's actually the back.
They're in the bottom.
You know what, there's pictures in your package. I'm not going to be able to find them. They're not individually labeled, so it's impossible for me to see. But, oh, wonderful. There it goes. One sec. Can I move them down this way? Yep. I think it's instrumental to show you. So here's a picture of what the house looked like when the Marazzos first bought the home. You know, and Hilldale is one of those very old streets in Middleton where the property line actually, you know, meanders about. So you can see here's the front view of the home. What they're proposing to do is to complete all the renovations of the house, which they had started. They want to continue to expand the front entry so that now the house will actually attach to the garage, and then the garage will be a 2-story home. So here's what they're going to accomplish. And I wanted to just show you. So this particular proposal to extend the front of the building, they had done it. I'll be honest with you, they didn't know they couldn't do it because they thought the property line was further out. And when I met with them about the 2nd story on the garage, I told them we had to come here to seek a special permit to be able to continue the work, which would expand this overhang. And as you can see, the overhang is a projection of the old, I'm going to go back. So anyhow, I can't wait to be in person again. So the Marazzos basically are trying to improve the area. It's, you know, they're a wonderful young couple, and what they're trying to do is make their home more beautiful. And Hilldale is, you know, while it's one of our older communities, there are a lot of great things going on there and a lot of great renovations, and this home is one of them. So basically, you know, the home is pre-existing, non-conforming. I submitted to Mr. Fitzpatrick a memo support of this particular application because there's some, I wanted to make certain that this is a special permit, because even though they're encroaching further into the front yard setback, there's case law that says further encroachment does not create a new nonconformity, and single family homes are entitled to a greater protection and therefore are entitled to simply get a special permit for that type of encroachment, to the extent that the board hearing the issue deems the change not more substantially detrimental than the pre-existing nonconformity. And I would offer that this particular view of the home versus, oh my gosh, I can't make it go up, versus the other one with just the one dormer is not substantially more detrimental, despite the fact that, you know, it is further into what would be closer to the right of way, because the existing street is still so far away and doesn't create any issues. And as you can see, you can still park a truck and have no impact with regard to that right of way passing. So basically, I would suggest that this particular change is a benefit to the community, adds to the community, creates additional value, and allows for Middleton to maintain its current appeal with regard to these older communities, yet allow them to refurbish and make them, you know, the first-time home buyer homes much more attractive and have wonderful benefits and improvements. And from that, I would offer it back to the board for any kinds of questions you may have. And hopefully I don't freeze again.
Thank you, Attorney Mann. Madam Clerk, could you read any correspondence received?
From Meld. Meld has no conflict with this project. From Derek Fullerton, 9 Hilldale, no issues. 3 bedrooms, new 3-bedroom septic system installed in 2014. No increase in flow permitted, meaning 3-bedroom dwelling only.
I believe that's it.
All righty.
Is there any other comments from Katrina or anybody else from the town?
No comment here.
And I will open it up to testimony from members of the public. If you could please raise your hand and we can call on you. Seeing none, I will open it up for board discussion.
Amazingly, no comment.
So this is like a recurring theme for questions of mine. Could you be any closer to the street? Are you actually within a foot of the street? Because it looks like it on the map.
Yeah, 1 second. I have to go. It's about 3 feet.
So we're still measuring in feet. We're not measuring in inches at this point.
Yeah, you're still measuring. You're still measuring in feet, but it's. I mean, Mr. Hartwell, it's close. There are other homes though on that street. There is close. It's. I know.
So a picture's worth 1,000 words, and a site walk is worth even more. So I would like to see the property before we grant forgiveness as opposed to permission on a project like this.
We understand. You'll be very impressed. They did a lovely job.
I don't know how the other board members feel. I think a site walk could be beneficial, but I mean, I don't even have any other questions until I actually see the site and kind of see the layout a little bit.
Love it. Love the idea.
So I'm going to make a motion that we set up a site walk for 6:30. Let's do 5:30.
Yeah.
On this. Yeah. So we'll head over to Hilldale before we head over to North Main Street. Does that work for everybody?
Yeah. So moved.
All right. So that will be on April 7th. The site walk at 9 Hilldale will be at 5:30.
Perfect.
Should take 10 minutes to take a look at it, 15 minutes, and we'll head over to North Main.
Perfect.
All right.
So moved.
And second?
I'll second.
And a vote?
Rich?
Yep.
Craig?
Yes.
Ann?
Yes.
And I'll vote yes.
And do I have a motion to continue to the April 22nd, 2021 meeting?
So moved.
And second?
Second.
And a vote?
Rich?
Yes.
Craig?
Yes.
Ann?
Yes.
I'll vote yes.
Thank you, guys.
Thank you. Have a great evening. Sorry about all the freezing.
No worries. Have a good night.
Take care. See you on the 7th.
The last item on the agenda, Attorney Mann, is the pedestrian improvement policy. I didn't know if you wanted to stick around for that. She's already gone. Given that it's 10 o'clock at night and I haven't eaten dinner yet, I'm going to ask that we continue the pedestrian improvement policy till the next meeting. Or we table that?
I think that's a great idea. I
So
would say
continue
too. Well, I was going to say, Craig, we may even want to just have a special meeting just to talk about this, so we don't take up the whole night and we're all not eating supper till midnight.
Yeah, we'll see how next week is, and we can kind of go from there if we want to. We'll give it one more month of see if we can fit it in. Does that work, Katrina?
Sure, that's fine.
Okay. All right.
Greg,
I don't think we need to vote to table that.
No.
Go ahead, Rich. Sorry.
I was just going to mention too, I've been in contact with Mass DOT, and I think they're interested in coming out and doing a sort of site walk up 114 and just kind of looking at things. There's a resurfacing project coming forward. They're going to be resurfacing Route 114, which is good news for us. But we can also look at some other things that have been going on 114 and get some direction relative to curb cut permits and all those sorts of things. So I'm looking forward to that. The meeting hasn't been scheduled yet. It'll be during the day. So, just kind of do a site walk up the street and just kind of look at things.
The board is always looking for additional information on zoning issues. So if anything you could pass on with that, or if there's a time that's open for public or board members to attend for that. If you could forward that along, that'd be great.
Okay, I'll let you know.
Awesome. Any other business not reasonably anticipated in the last 48 hours?
The last 15 minutes.
Can we rewrite the whole bylaws in the next 4 minutes?
Move to adjourn.
So moved. Vote yes.
Yes, yes.
Yes.
Everybody voted yes, yes.
Good to
Have a
see
good
you,
night,
everybody.
everybody. Don't turn off the camera.